All right. Good morning, everybody, and thank you for being with us today for our final installment of our February winter webinar series. We hope that you've enjoyed the collection of topics that we've covered. And again, as always, if there's something that you are struggling with or interested in or would like the MBG to put on a webinar or seminar about, please don't be shy in letting me know. I exist to serve you. I want to make sure that you're getting what you need and that we're putting forth tools and resources that are really helpful. So that is why I'm so excited to have Tanzi with us today. Many of you already know her, love her. She's been a part of the guild since I've been running it, so 9 years as a co-owner of Brew Practitioners, and she's also a legal expert. So we tend to we lean on Tanzi whenever we have questions. She's always great about answering them without the meter running. So definitely lean on her as a resource for the association. So today she's just going to be covering some human resource updates. These are always moving targets, so it's really good to try to stay on top of the ever evolving changes that we're dealing with statewide or federally. And I know we did have some members specifically ask about ICE related issues, and I know she's going to touch upon that as well. Obviously, today's webinar could probably be five easy. So if you have any clarifying questions as we're going through, please feel free to type those into the chat, and I'll be sure to pause Tansy and ask her to explain. Otherwise, we'll save questions for the end, but you can type those in at any time that you're thinking of them so you don't forget. So without further ado, Tansy, please take it away.
Good morning, you guys. Thanks for being here. So I'm just gonna, like Katie said, this presentation is loaded with some general topics. I could easily train on this in an 8-hour session and still have more to talk about. So I am going to fly through some of these topics, gloss over them. Uh-oh, why isn't it switching? Oh, there we go. I'm going to gloss over them, um, provide as much detail as will give you a general idea of the topic, but also try to reserve some time at the end. So in 45 minutes, I'm going to cover a whole bunch of stuff. So if I go too fast or you have questions clarifying questions, please let me know immediately. Always, I will be available offline if you have additional questions as well. So, with that being said, here's just my qualifications. I always put these up here to let you know why should you even think I have any business talking about this subject that I'm going to talk about. And here's the reason why. I'm labor and employment and business attorney. I've been doing this for that particular area of law for about 15 years. Certified diversity, equity, inclusion officer, even though that is, quote, kind of a bad word today. I'm going to explain how that still actually applies during this training. I'm also a certified workplace investigator. Some of this stuff touches on why that's important and how you can incorporate that into your daily operations in order to protect the organization as well as any of your managers and supervisors if you are in that particular role. I'm obviously a corporate trainer. I do corporate training across the board for lots of organizations and fractional general counsel. That just means I am outside general counsel for multiple organizations, meaning I can offer advice and counsel in regards to a multitude of topics without actually having to be on site staff, adding to that overhead, if you will. So, with that being said, today that's what's on the docket. We're going to talk about harassment and discrimination in the workplace. And I know that you guys have probably already go over your harassment and discrimination training. Most people have an online platform that they use. I am going to narrow that topic here today. And the reason why I'm still bringing it up because what's happening at the federal level is actually impacting how we engage with harassment and discrimination analysis in our workplaces. And I just wanted to touch on those nuances. With that, I'm going to talk about the EEOC updates, and that's how that's going to impact this harassment and discrimination in the workplace. And then we're going to talk about how the war on D&I in the workplace is taking place and why we should care, and how we need to, how that will impact our operations. And I frankly don't think it's as impacting our operations as much as in New England as it is elsewhere in the country, but we're going to talk about that as well. And then I'm going to touch base on ICE and what ICE's rights are and what the employer rights are and what the employee rights are, if in fact there's a raid, and what we can do in those moments. So I'm going to start first with sexual harassment. Again, by Massachusetts law, we have to engage in sexual harassment training across the board at least once a year, if not every 6 months. Um, it has to be a 2 hour training. This is not a 2 hour training, but it also will help you say that I've had some additional sexual harassment and discrimination training just by checking that box. And it goes towards what we call the affirmative defense. If in fact an organization ever gets sued for some sort of harassment or discrimination claim. So, sexual harassment, unwelcome conduct that involves sexual advances or requests for sexual favors in the workplace. If there's a submission to a rejection, it becomes a condition of the employment or some other discipline action, then that can be considered what's called quid pro quo sexual harassment, or if the conduct has a purpose or effect of unreasonably interfering with the individual's work performance and creates an intimidating and humiliating sexually offensive work environment. It's important that we understand the distinctions between the two. I will step into that, but it's also important to understand that anyone can be harassed, and it doesn't have to be the target. Intention doesn't matter. You can be a bystander. The standing as to who has a claim for harassment in the workplace is actually quite broad. So here are the two separate types. I just touched on those, and I want to point out in this particular case why it's important to know the distinction is because with quid pro quo, there's no defense to it in the law. So if in fact one of your employees alleges that they have experienced quid pro quo sexual harassment in the workplace and they can prove that a statement was made, that the threat was made and it was a viable threat, that the company will be on the hook for any sort of that allegation and possibly a supervisor and manager as well. There is no defense in a law. It's called strict liability to an allegation of quid pro quo. So what does that mean? Quid pro quo sexual harassment means there's a person of position and authority that has the ability to impact an employee's job, like whether or not they're promoted, whether or not they move their desk, whether or not any sort of aspect of the job that someone has supervisory authority over can be in the position of authority. And the law says that titles don't matter. They look at the job description and how it impacts the other subordinate person. The second part is they have to offer some sort of sexual conduct in exchange for a benefit or not being presented with an adverse employment action. So with this for that, if you don't have sex with me, I'm not going to promote you. If you don't go on a date with me, then I'm going to, put your desk in the back corner. It can be as simple as that. What's important to also know is that the threat is sufficient. They don't actually have to go through with the act. You don't actually have to refuse a date with me or go on the date with me. You don't actually have to demote the person or you don't have to fire the person. It's enough, the threat is sufficient enough. If they can prove that the threat has happened, then quid pro quo sexual harassment has occurred and the company is on the hook for liability if in fact they go to court. So what do we do about this sort of quid pro quo? Usually this is rare. It doesn't hardly happen anymore. This is the kind of stuff that we watched on Mad Men and things like that. Usually by the time you're in a position of authority, you have either been trained enough times to know that this is an inappropriate conduct and it's no longer acceptable, or they've worked themselves out of the organization and haven't made it to that higher position. Now, sometimes it does happen. So it's important to know that this is it. Even if you have the inkling that something like this has happened, we need to work this person out of the organization. And usually, and most HR people can tell you, usually we're hiring smart, right? We're preventing these people from getting in the organization and they're weeding out early. What we usually see is the next one, which is the hostile work environment. If I can figure out how to get to the next slide. There we go. So what does it mean for a hostile work environment, sexual harassment? It means the employee was subjected to conduct of a sexual nature. The conduct was unwelcome, and the conduct of the sexual nature has the purpose or effect of creating an intimidating, hostile, humiliating, or sexually offensive work environment. So having the purpose or effect, what that means is that it can be intentional or it can be unintentional. So you could be totally intending to be a creep, or your whole environment could be, the whole workplace could be unmanaged and conducting itself in an inappropriate way on purpose, or it could just be someone doing something stupid that they shouldn't have done, but the purpose of that created a hostile work environment. So the bottom line there is the court doesn't care what the intent is. If it's a hostile work environment that creates an intimidating environment, hostile environments, pervasive, then it will be considered a hostile work environment. This fourth element, these four elements, actually, let me back up a little bit. This is called the prima facie case. In order for someone to sue an organization in court, they have to make out these four elements in order to get past the MCAT, if you will. In order for a complaint to move forward, they have to be able to prove each of these four elements happened. So I highlight this fourth one because this fourth one is where our managers and our supervisors who are on our front line can actually help us, and how our consistent management and equitable management of our staff can help us in our defense and keep someone from alleging a hostile work environment. And how this helps is by managing the performance. If we're managing the performance reviews or making sure we're documenting all instances of discipline or even positive things throughout their time of employment, then I have enough information to answer that question, whether or not the conduct, the sexual conduct or conduct of a sexual nature interfered with the complainant's work performance or altered the terms and conditions of the complainant's employment. And I highlight it here not only because this information comes from day-to-day activity, but because most organizations, when I've gotten a complaint and I've had to answer these responses, they overlook them. And so the court will infer it. They'll say, well, obviously, if it's unwelcome and it's hostile and intimidating, it must have altered the terms or conditions of their employment, or it must have interfered with their employment. And so a company has lost out on the opportunity to put forth a defense when they don't consistently manage the performance of their employees. Because if in fact someone has felt like they are being harassed, and I go to a manager or supervisor or company owner and I say, hey, can you tell me about their performance? And they can pull out their performance reviews or say their salesperson, their production, and they say, actually, they've been doing a really good job as compared to last year, then they don't meet that number four element. However, if I go to you and I say, hey, can you tell me about the performance? I'm like, oh, I don't know. I feel like it's been the same. Then we've lost that opportunity to defend that claim. So this is how in application in our everyday operations, we're training our managers and supervisors why those performance reviews are important. And I can go on and on about this. I'll skip past it, but if anybody has any questions later about that, we can definitely dig into that. So that first element, it must be unwelcome conduct. In our industry, in the brewery industry, I think this is important to point out because not all harassing conduct, which would from objectively appear to be harassing, like, oh, that looks like a little something untoward's going on over there. If in fact the alleged complainant or the complainant who alleges harassment is actually engaging in that conduct that they are subsequently saying was harassing, then it's not unwelcome. And we need to make sure that we're noticing that and documenting, those type of instances. However, just because a person engages in the conduct that is alleged to be harassing doesn't necessarily mean that it can't later become harassing. If they retract or they retreat from the conduct and say, you know what, went a little bit too far, now I'm out, but the alleged harasser continues to engage with them in that unwelcome way, then that could be considered unwelcome. It's very fact and intensive inquiry. But the reason why I bring it up is because it's another area of defense that a lot of people overlook because they're not documenting what they see, what someone has actually reported to them or asking the appropriate questions. Now, so what does it mean? So it's unwelcome conduct, it's conduct of a sexual nature. Pretty much anything can fit into the definition of conduct of a sexual nature. It's a case by case scenario. But the question is when do we know it's intimidating or hostile enough to become a harassing work environment? And so the court said that it must be objectively harassing, must be offensive from an objective point of view and a subjective point of view. And essentially that an employee, if they are inflicted with a conduct of a sexual nature, that they actually have to be offended, which that's an easy one because they wouldn't have come to you if they weren't. So that's the subjective standard. The objective standard is that a reasonable person in their shoes would also be offended. And so I skipped ahead a little bit. So what does that mean when it's objectively harassing enough to be an intimidating and hostile work environment? So the court has said that it must be severe and pervasive, right? So the pervasiveness means that there's a steady barrage that happens day in and day out, and it's not being addressed, right? And it could come from more than one person. It can come from Kate saying something inappropriate, and then Jack grabbing, someone's behind. It can come from, a poor taste poster hanging somewhere. It's a conglomerate of the complete environment, hence hostile work environment. The court will take into consideration a time period, so a scope of time period, as well as an environment. So what I would do is, first of all, I want to define that environment. First of all, what is this environment we're alleging is harassing? And what's the timeline? So we want to make sure we limit that. And then we look at that, say you're a fly on the wall. Is there a multitude of inappropriate conduct? And if there is, it can be considered pervasive enough to be a hostile work environment. Now, the next standard is severe. Very rarely are you going to have conduct that is severe enough that one isolated incident is going to be considered a hostile work environment. However, it does happen, and it would be an unwanted touch or something that, I mean, we can try to come up with examples all day long, but something that is so extraordinary that an isolated incident would become a hostile work environment. Again, that's kind of along the lines of that quid pro quo. Usually, the people that conduct themselves that way have worked themselves out of the organization a long time ago, if we're properly managing our folks. Most of our hostile work environment claims are going to come from that pervasiveness. And this is stuff that our managers and supervisors, those people that are on the front lines, can easily prevent from happening just by consistently holding people accountable to the rules. So then we're going to go on and talk about other unlawful harassment and discrimination. And this is just harassment that isn't sexual conduct, right? It's the other harassment. It's the harassment based on protected class. If not for this person's protected class, they would not have been harassed. So it's the same type of prima facie case. It's the same standard that we just went through. It's unwelcome conduct, communications conduct that is based on their protected class, is some sort of derogatory statement or some sort of negative act based on the protected class that creates an intimidating, hostile, or offensive work environment. It must be severe and pervasive, and it must interfere with the work performance, right? So this is back to what we just talked about, right? We're consistently managing the performance of our employees across the board. We're doing it in an equitable manner, everyone across the board, and we're making sure we're having those difficult conversations early so that we can knock out that pervasiveness. Now, next thing is discrimination. Discrimination, it's unlawful to discriminate based on the membership of a protected class. There's lots of people mix up discrimination with harassment. I just want to point out that in order to discriminate against someone, the person who is alleged to be doing the discrimination has to be in a position of authority, because it has to have a negative impact on the work environment. And if you can't negatively impact someone's job, if I can't demote them, I can't reduce their pay, I can't take away their hours, I can't, move their work section, then I am not in a position of authority, so I can't have inflict an adverse action on the employee. So position of authority must be able to inflict an adverse action. Now, this third one, they met the employer's legitimate expectations of at the time of the adverse action. This boils back down to those performance reviews. This is the prima facie case. They cannot allege discrimination unless they can prove I've done a good job and I've been doing it on a consistent basis. Now, when you get a claim at the MCAT, they're going to check a box. Yep, I did a good job, best employee ever. And they always say that. Opposing counsel will always say, best employee ever. They were awesome, so much more awesome than anybody else. We need to be able to defend, well, no, they weren't. Actually, during this time period, I had multiple conversations that they weren't performing appropriately. They were late to work every day. Their customer service was wanting, whatever it might be. If in fact there's anything that happens during that time period that tells us that they're not meeting the legitimate expectations of their role held against their job descriptions, then they don't get in the door. They don't get to sue. However, that defense goes to the wayside if we're not consistently monitoring the performance of our employees. The next thing, the fourth element, is they have to prove that they are being treated different from a similarly situated employee outside of their protected class. So we're looking at similarly situated employees based on their job task, not necessarily their job title. This is, we would want to look at the job descriptions. Anytime you get an allegation of discrimination, one of the first things the investigators look for from the EEOC or from MCAT is they're going to ask for those job descriptions because they're looking for those similarly situated employees. When we are consistently applying policies across the board, and we do it in an equitable manner, they're never going to be able to prove that they're treated different from a similarly situated employee outside their protected class. I know this is so fast. Here are your protected classes. I'm not going to go through them. I just want to point out some of these ones that we're to see where it says the EEOC changes. This is where it's going to newly impact the workplace. And I'm going to talk about that in just a second. The EEOC has come up with, they have stepped back from some of their guidance and they have removed some of these protected classes. And how that impacts the workplace is it used to be that these protected classes were based on historically disadvantaged individuals so that we can make sure that our workplaces are equitable. Not equal, but equitable, that we are applying our policies and procedures equitably so that everyone has the opportunities that are like similarly situated individuals. Well, the EEOC has said that they're no longer enforcing some of these protected classes and based on that historically disenfranchised individuals. So color across the board is no longer just going to be people of color. Color is going to include your Caucasians. National origin, they are now on this platform, America First. So it's no longer going to be I'm being harassed because of my origin is from Africa. It's across the board, any national origin. Race, same thing. Sexual orientation, the EEOC has actually put out information that they are no longer enforcing existing complaints that are discrimination and harassment based on sexual orientation. And then now the Supreme Court has actually had a ruling that states that the EEOC, the previous EEOC before this new administration, actually overstepped their authority by including sexual orientation into a protected class as a basis of sex and gender. So they are no longer supporting at the federal level sexual orientation as a protected class. Now, does that mean that you can harass and discriminate on the basis of sexual orientation? No, it does not. Two reasons. First of all, it'd be a policy violation. For most organizations don't want you to conduct yourself in a way that's harassing regardless of sexual orientation. And the second thing is the federal law does not supersede Massachusetts law. And for Massachusetts, these protected classes still exist. So we're still conducting ourselves in a manner consistent with, company standards of conduct, as well as these more strict categories that Massachusetts has put forward. And the reason why it's important for you to know is because this is actually in pop culture now, that the EEOC is enforcing and suggesting that people, first of all, A, don't abide by sexual orientation protected classes, and B, if you're a person that is outside of a historically disadvantaged protected class, that you look to make sure that you're not being discriminated against by any of the company policies. They're actually putting a call to action out there for people to look for this. How do we mitigate that? Make sure we're equitably applying the rules across the board to everyone, and that we're consistently applying the rules. We can't sometimes apply them and not apply them because that's ripe for allegations of discrimination and harassment, especially some of those what historically we would call reverse discrimination, but now they feel like the EEOC is asking for people to, tell us what's been happening to you, and they're being vindicated, if you will. Who can be harassed? Everyone. This is important because we are retail organizations, right? Employees can be harassed. Employees can harass supervisors and managers. Usually that doesn't happen if we're appropriately supervising and managing, but it can happen. Coworkers, non-employees, our employees can harass our vendors. People that come into our organization, they can also harass our customers and vice versa. Like our customers can be harassed by our employees, and we have a duty to protect them once they are invited onto our floors. And sexual harassment, just important to bring up. Historically, it used to be that it had to be in a romantic relationship or female and male. No longer the case. Probably about 15 years ago, they actually changed that. Gender or sexual orientation or desire and intent no longer matter when it comes to sexual harassment. Anyone can be harassed. I know I'm going really fast through this vote, so I am happy to entertain any questions later. So, and where can it happen? Any place in the work, anywhere in the workplace, and anywhere outside the workplace if it's a sanctioned workplace event, as well as if it's outside the workplace, not a sanctioned workplace event. However, it works itself into the workplace and someone is having to cope with it at work. At that point, it becomes company's business to make sure that they're mitigating or ridding of any of that inappropriate sexual conduct or inappropriate conduct in the workplace. Who's liable? Harassers liable. They can be sued civilly. They can be obviously held responsible at work, discipline, or termination. The employer is strictly liable for quid pro quo. And the manager or supervisor, if they don't do the things that they need to do, can also be held liable. And I've seen plenty of cases where manager was named as a co-defendant. We talked about this strict liability for quid pro quo. Hostile work environment, though, there is what's called an affirmative defense, which means, yes, this thing happened, but we're not liable. Our affirmative defense is going to be that, we did a timely investigation. We have anti-harassment, sexual harassment policies. We do anti-harassment, sexual harassment training. As well as when we did that immediate investigation, we kept an employee safe, interim remedial measures, and then we made sure that we did everything that we could do to keep it from happening again. It's a fact-intensive inquiry, but for the most part, it boils down to making sure that you do a timely reporting as well as a timely investigation, and then implementing any of those remedial measures that are necessary based on the findings of the investigation. So this is get to this nugget of the updates to the DEI and EEOC. So I have done training in the past for several organizations, including the breweries, DEI training, how we're going to incorporate this into our workforce. Now the administration has stated that we're doing away with DE&I. As a matter of fact, if you actually engage yourself in DE&I practices, we're no longer going to give you federal funding. We're going to be looking at you with strict scrutiny. The EEOC is jumping on board. We just talked about this, the reverse discrimination. What does that mean for our workplaces? On the surface, it looks like, oh my goodness, now I've got to dial back all these things. But in practice, actually, no. We just need to make sure that we're looking at the letter of the law and that we're applying the protected classes across the board. And if we're implementing our policies and procedures on a consistent basis based on conduct, not a person's being, then we're going to be okay. However, some of that changes that we made to our handbooks, some of the changes we made to our policies, some of the trainings that we do, we may have to go through and review those things just to take some of that suspect wording out. But in application, if we've been applying our DE&I principles appropriately across the board from the beginning, nothing is really changing. Again, however, on the face, it may appear so, and we want to make sure that we don't get stuck with someone coming in and say we're doing something wrong because it's harder to prove in application how we're applying things than it is on how it looks like in a policy or procedure. So how has the administration done this? So it started out first with some executive orders. Here are several executive orders that the administration put forth that essentially is anti DE&I. Then what happened? So it said for the federal government, this stuff trickles down. Federal government says it, and then it trickles down through some of the administrative agencies. And even though the state agencies have autonomy, they often defer to the federal agencies because at the end of the day, the federal agencies are the law of the land. However, you can be more strict than the federal law. You just can't be more lenient if the federal law is stating that it wants you to be strict in a certain way. If the federal law says, oh, you need to be more lenient here, then you can be more lenient, but not more strict, if that makes sense. So anyway, here are some of the executive orders that put forth that have started along this path of how we're changing how we work in an organization. It rejects the concept of gender ideology. We talked about how the EEOC has made those changes already. It talks about appropriate measures to end illegal discrimination and preferences. They're starting to impact some of the funding. They're doing grant fundings based if you have DE&I included in your policies and procedures. A lot of that's not going to impact Massachusetts businesses, but it could. We just want to make sure we're doing a surface review of our policies and procedures. And then eliminates the disparate impact liability under Title VII, which this one is not really going to impact companies right away. But what a disparate impact analysis involves is like on the face of a rule that we are writing or enforcing, if in fact it looks neutral, but in application it impacts a protected class in a way that we didn't intend, but it still impacts them in a negative fashion, in a disparate fashion, then it's called disparate impact liability. The executive order says we're no longer even looking at that. I don't care if it impacts a protected class in a different way. We're not even going to waste our time on that. However, Massachusetts still will. Here's some of the federal cases that how it has boiled down. The Heritage Foundation, essentially, this is the start of where they said that the EEOC can no longer enforce sexual orientation, that the protected class of sex and gender does not include gender identity or sexual orientation, that the EEOC overstepped its authority by broadening that protected category in violation of Title VII of the Civil Rights Act. So they're dialing back again. And we just talked about that sexual orientation protection. But again, Massachusetts is still going to enforce that. So the EEOC has put forward several pieces of guidance on what it wants you to do because of those executive orders. Now the courts are starting to follow suit. Now the EEOC, an executive agency that the MCAT answers to, is now saying, okay, this is how we want you to act. There's several of these guidances they've put forth. What to do if you experience discrimination related to DEI at the workplace. This is going to directly impact our workplaces. If people get into it, and they already started to have, they're going to start scrutinizing everything that we do with discipline, with promotions, with preferred schedules. They're going to be looking at this and saying, well, you're, discriminating against me, especially if we have had a strong DE&I posture moving forward, which a lot of our New England organizations have, and for good reason. However, if we make sure that we are promoting and doing all work-related decisions based on performance and conduct and behavior, not on someone's person, and we're doing it on an equitable basis and consistently across the board, we're never going to have to worry about these allegations of discrimination. Again, they started to talk about how they're going to keep federal funding from agencies that are engaged in this DE&I in their workplace. Now, and what I don't want for us to take away from this is that we have to remove all things DE&I in our workplace, right? I want to offer the explanation that we can still conduct ourselves in an appropriate way. We just need to be wary that these things are out there and that we need to review our policies and procedures so that we're not using inappropriate language that will all of a sudden, get us in unnecessary trouble. This was the case I was talking about, which they're now encouraging people to use the sue. So it used to be, again, historically, people that were in a protected class that didn't have the rights or the benefits of the historic majority group. Um, it used to be that if you were outside of the protected classes, you were not in the minority, but you were in the majority, you had to show something more, right? It wasn't just on your protected class, but there was something more. Now, it's the First Circuit did not do this. These are other circuits, but we have always, Massachusetts has always been consistent, with gender and class and based on protected characteristics, your race, your nationality. However, with this Supreme Court case, it specifically says no. We're looking at the plain language of the statute and of the regulations, and it doesn't matter if you're in the minority class. It doesn't specify you have to be in a minority class. It says race, it says gender, it says nationality. Everybody fits into a race, everyone fits into a gender, everyone fits into a nationality, including white people, including heterosexual people. In this particular case, it was based on sexuality. So what this means is that we're just looking at the plain face of the statute and that we're no longer saying that, is this person in a protected class? Do I have to worry about them suing? Everyone is going to be in a protected class, essentially. What are your takeaways with increased litigation around DE&I and increased scrutiny? We want to make sure that we're initiating any work decision, any discipline, any accommodations based on just our conduct, our performance reviews, and any sort of incident that occurred that has nothing to do with one's person, nothing to do with a protected class at all. When an incident does happen or some allegation does happen, one of the key takeaways is you must do something initially. Some of our breweries don't have human resources departments, but there's someone in that organization that wears that hat, right? So we need to make sure we're defining who that person is and who I report this type of conduct to. So timely reporting of a complaint is part of your affirmative defense. So we have to make sure that we report it to the appropriate person in a timely manner, and we do a prompt investigation. Investigations don't have to be these full-fledged, full-scope investigations. They can be just as easy as having a conversation, reporting it, have a conversation, analyzing or doing an analysis as to whether, the incident actually did occur, and then finding out what we do later. Prevention. So what do we do to prevent any issue in our workplace? Harassment-free policies, all employees trainings, meetings. We have to have a complaint process and they have to know about this process, consistent accountability. And for our affirmative defense, if somebody does make an allegation, why should we not be liable? We've got complaint protocols. Everyone knows about those protocols. We have investigation protocols for our, if not HR person, our managers and supervisor or whomever is going to be wearing that investigator hat. And that we are able to identify and implement interactive remedial measures, meaning once you implement something that's going to make that employee feel safe or remove that harm, that's not just a one thing that's done. It's interactive. You have to go back, how are we doing? And those type of things. And again, I'm flying through this stuff, but this could be a whole day training in and of itself. Let me check my time. I got 3 minutes and I want to get to this ICE stuff. So we're going to skip through this equitable accountability. It is a practice. We have to make sure we are consistently practicing this. This documentation is extremely important. I'm sure Sarah will back me up on that one, but I want to get to this ice stuff. And you guys can look at this presentation online. So when it comes to ICE in the workplace, what are the rights? First of all, what does ICE do? They're going to do your I-9 audits, and they're just there to make sure that the people that are working in your organization are legally able to work there, that you've got your I-9 credentials done appropriately. They're going to hold the employers accountable if you're just being laissez-faire about your record keeping. And then, of course, the allegation is they want to prevent exploitation of immigrant workers from, being not paid minimum wage, those type of things. Um, that is in the mission statement. That's actually not what's happening right now, but that is important to know that that's one of the purposes. Even if you are violating your I-9 responsibilities, you can correct those things. But if you're violating your I-9 responsibilities, you're purposely hiring illegal workers and you're underpaying them, those are three different distinct violations that will be held to be violative in a different way. And if you're not properly paying wages, I can have a whole training on wage violations. That's strict liability. There's no defense to it. Treble wages and attorney's fees. Why is this important for breweries? Because we have a high turnover rate. So I-9 inspections, what will happen if what they're looking for, they're going to give you a notice of inspection. You'll have 3 days to respond to that, which means you'll have 3 days to get the notice of inspection will tell you what they're asking for. Most likely it's going to be, history of pay, who's on your payroll, who's been employed by you. They might want your articles of incorporation. They can ask for something that's relevant to your business and your hiring there. They can do an on-site inspection and things to follow up to make sure that if you are still storing that stuff on site, that it's being stored appropriately. It's supposed to be separate. There's a whole protocol about that. What do you need to do? Make sure you centralize your I-9 storage. Most people are doing that electronically now, that you designate someone who's responsible for it that understands that you have a standard operating procedure and they understand that standard operating procedure, and that they are consistently following all the time, the timeliness. Like, so if you have to redo an I-9, when you have to redo an I-9, those type of procedures. It's important to make sure that there's at least a standard operating procedure and you have at least one or two designated people that can manage that. And if there is an audit, that you have that person come forward. Probably your manager on duty at the time should know where they're kept, what they need to do if someone seeks a notice of inspection. Here's what it would look like. This is a graphic. You'll see this online. This actually comes directly from the ICE website. It's just a flow chart, what to do if and when. It's an it's good to know that, like, when there is an I-9 audit, they do give you multiple opportunities to correct. Only in the end where you get fines is if you're really don't fix the issue, or you've every time they come you have an issue, like you're a repeat offender type of thing. They do give you opportunity to correct this type of thing. Here's your checklist. Ensure that the documents are up to date, that you have proper storage, and that you're retaining it according to the proper retention schedule. Um, do internal audits. Make sure that the people that your managers on duty are trained appropriately. So what do you do when ICE shows up at the work site? Um, so ICE has rights, and the employer has rights, and employees have rights. Make sure everybody knows what those rights are. Get some simple training, some checklists. A standard operating procedure would be good. Make sure that the employees know that knowing that what their rights and their responsibilities are, and using those rights and responsibilities, presenting them in a professional manner is going to be more conducive to ICE getting in and out than acting in an extraordinary manner. Oops, sorry. So what do we do when ICE arrives? So make sure that we have, did I skip a slide, or maybe it's next? Okay. So what ICE has the right to do, they can come in, they can come into public areas, they can't go into private areas, unless, of course, they have a warrant. There are several different types of warrants. They can have an administrative warrant, which means that they can check paperwork. But if they don't have a judicial warrant, they can't go into those private areas, like they can't go into the back office, they can't go into the kitchen, they can't go and do an investigation into areas that are in those private areas. If in fact they can in a public area, and where if you've got people in the public area, they can ask questions. They can say, I want to see your papers. I want to, are you an American citizen? They can ask those questions if they're in a public area. However, employer does not have to if they ask about Bobby, is Bobby here? Employer does not have to say, yep, Bobby is over there. Employer can say, you know what? It's our policy not to engage in this. Also, Bobby does not have to say, yep, I'm an American citizen, here are my papers. Bobby can say, I'm invoking my right to remain silent. Now, what happens then is if the ICE agents may leave or they may detain Bobby. At that point in time, Bobby should ask for an attorney, and you should find out where Bobby is going to be detained and then communicate immediately. If in fact you don't have an attorney, you can ask for a public attorney in that moment, and they're supposed to engage in that. The best course of action is to remain calm and not instigate, a violent situation. So what should we do? Make sure we designate what's a private area and what's a public area. Frankly, I think all of us have those signs up that say, staff only. Those are going to be your private areas. Train your reception and your security and supervisors on these boundaries and the protocols. Make sure that we know the difference between a judicial warrant and an administrative warrant. Like it will say it's signed by a judge if it's judicial. It will say it is a Department of Homeland Security will be right on the front of it if it's an administrative warrant. Administrative warrant is only to look at documents. It's like a paper audit. Judicial warrant, you have to have a warrant to go into private spaces and do what a Fourth Amendment search, right? That would come from a search warrant. Or you have to have a warrant to actually arrest someone. Detaining for a particular period of time, it looks the same as an arrest warrant, but technically it's a little bit different. They can have a subpoena for specific documents. I would abide by those subpoenas, but don't let them follow you back into that private area. How do we stop that? Can't really. We can say, you know what, this is a private area. You're not welcome back here. Our recourse here is only to fight those actions at that next step, which would be in court. Designate an on-site response coordinator, review. Most of us don't have union workforces, but if we did, we need to make sure that our responses and our expectations of our employees are consistent what's in those CBAs. And then, of course, maintain and organize I-9 record. If we can say, you know what, here you go, all is good, see you later, then really why are they still there? When ICE arrives, we're going to make sure we stay calm. We notify the response coordinator, if it's manager on duty, facility supervisor, someone that's in a position of authority to make these decisions, someone that we say, you know what, we're not going to talk to you, talk to that person over there. Ask the agents to wait in the designated area. You can ask for them for their badges, for their identity. This, no face, no badges. We as employers have a duty to keep our workforce safe. That comes directly from MCAD regulations. It also comes directly from OSHA. We have the general safety clause. So if we have some masked individual coming in and harassing our folks, we have a duty to keep them safe. So when we ask for that identity, that's one step of keeping our workforce safe. Ask for the purpose of the visit, an audit, a search. Let me see your warrant. Here's a statement that you can say if there's no judicial warrant, this is private property. Company policy does not permit entry into non-public areas or access to records without a judicially signed warrant. Never block or physically interfere with an agent, and document, this is important, document your encounter, everything that happened, and get documentation from several people of this particular incident. Because if later you do have to go to court to defend yourself or to enforce some right that the company has, we're going to need contemporaneous documentation to support what actually happened at the scene. After ICE leaves, we just talked about this, prepare an incident report, notify your legal counsel if they're not already there, notify the union if it's applicable, communicate openly with the employees about what happened. We don't want to keep this under wraps. We want to, break this down. This is what happened. This is what we learned. This is what we're going to do next time. Um, and then, of course, how do we treat the people that may be detained? Are we going to process their unpaid leave? Because remember, they're still our employees, so they might need to be on leave of absence. We might need to be paying them PTO, whatever that might be. And then review any follow-up requests that ICE might have left with your attorney to make sure that we're complying. Because what we don't want is them to keep coming back or to tag the organization as a repeat offender or someone who is hostile to the process and is not complying. Because then you're going to get repeated audits, you're going to get repeated visits, and then you might actually be fined later on. I think I did it. Only 7 minutes for questions, but fire them at me.
Yay! Thank you, Tanzi.
That
I
was
know
a
that.
lot so fast. I feel like I was in a game show.
Yes, no, I mean, you did incredibly well. So I know I'll give folks a couple minutes to chime in and ask questions. Sarah, feel free to unmute yourself to spare your fingers. I know you always have a lot of great questions. Um, Obviously the ice stuff is pretty scary, pretty overwhelming. Is there anything that you recommend or that we're able to do? Like I've seen some folks have cards printed in different languages to support their staff so that they can, in that moment, you're not going to remember, you know, this great webinar, right? Like, so how can we prepare ourselves for the possibility or prepare our staffs, or what are we allowed to do as employers as well? Like, are there
Right.
any kind of like tools that you recommend?
So as as a business attorney that I engage in businesses of all kinds across the board, the one piece of advice I give people all the time, well, a couple pieces of advice is continual communication, right? This is a practice. As employers, we are practicing within our company. I practice law. It's a practice, and we say it's a practice because it's never a one and done. So we can provide a toolkit, these checklists of things to do. And if we want to have written statements, I am all about a script. Right? If you can stay on script and whatever tools you can create to keep you on script, that's perfect. But what I would do is I would have if you're doing your jumpstart meetings, when we create like one of these short toolkits, this is what your rights are, this is what you can say. Let's talk about this on a daily basis. That does a couple of things. It makes them feel prepared, they'll be less stressed out, but it also opens up those conversations so that your employees can start talking to you about this stuff. Now, obviously, it can go off the rails pretty quickly, but if we keep it to, the standard operating procedure, do you have any questions about what you're able to say and what you're not able to say, then that's great. I mean, but doing it on a consistent basis, monthly, weekly. I mean, this is not Massachusetts is not in the eye of the storm right now, but they are surrounding. So, and especially in Boston, where you guys are out east, we're not as highly populated out here, but you guys might get hit, and it's going to be important that you can have those conversations with your employees. Even if we shoot out an email and say, hey, if you guys have questions, sending out an email that says, here's the process isn't going to be good enough, right? Because they're going to forget. But if we're talking about it all the time, even role playing will be helpful.
That's helpful. Um, and also, I'm curious to know, like, obviously, we're seeing so many changes from the current administration and things that our business owners need to keep on top of, both federally and statewide. Is there a go-to resource or website, or maybe it's your own newsletter, that can help keep our small business owners up to date? Like, is there a go-to, a holy grail of that makes it easy, puts it all in one place, makes it digestible. Any
Uh,
ideas or thoughts?
well, so it depends. Age-old
The
attorney answer, right?
perfect attorney answer. It depends.
So there is so much. I think what we have to be wary of is just going on anybody's blog site because not everybody knows exactly what they're talking about. I think the best answer is always go straight to the source, right? So I read Supreme Court justice or Supreme Court rulings. I actually read those, and then I read the comments, and
They
I
don't
read
put
the
you to sleep immediately.
no, I actually it was my favorite class in law school. I love reading case law. Um, and you have to, if you are curious about something that's happened at the EEOC, anything that has to do with harassment and discrimination, go directly to the Department of Labor website. Go to mass.gov. If in fact you don't want to, I mean, you can Google it, you can, AI it or whatever you want to do, but do know that that information is only as good as the person that put it on there. Do you know that person? Do you know where they're gleaning this information? You want to go direct to the source, something that you would cite as a reference to communicate, or to find out your next steps. Easy way to do it is, do you sign up for some of those law firm subscriptions that kind of put out that information, because we're held to a higher standard. Like I can't just say anything. I have to make sure that it's verified, that or I could be ethically in trouble with the bar. Um, or to make sure that if you're due going online, that you have a practice of verifying that information. Um, Lots of attorneys or HR organizations, they do have, a call in, ask a question type of thing. If it's a legal question, most of your like your EANs, and they're going to be hesitant to give you a response. They may direct you to someone. I'm always available for questions. Um, but honestly, having someone, even if it's a mid-size or a small size brewery, at least having someone on call that you could call when some serious stuff comes down, that's kind of important. You need to talk to the owners. Who is your designated legal guidance person? Most of your larger organizations are going to have a law firm that they use, or a HR organization that they use, or they may even have an HR department. Those are great. A lot of us don't have those HR departments. The question is, where do they go? Um, and I would say go to your owners, that they really should have someone that they could go for advice and counsel. Your larger organizations, they're not going to want you to call their attorney. So just know who do I ask these questions to, and how do I assure that you're going to understand the seriousness of this question, so you ask the attorney type of thing. I hope that answered your question, but it is convoluted.
Yeah, I mean, I always try to share any tidbits that come from Tanzi and her practice, as well as our friends at Bowditch who also do employee law. So anytime I see anything, I do try to put it in the newsletter, share it in the Facebook group. So if those are places that you are, I always recommend that you read my newsletter. But I try to weave in as many important compliance and HR related updates in there as possible. Also, if you don't have an HR person dedicated to your business, like Sarah Lee over at the Hendler Family Brewing Company, I'm picking on her because she's here. Um, but if you don't have someone dedicated to that, we do have the Northeast Association of Employers, their resource, as well as a couple HR consultants that are there to kind of come in and help you deal with a mess. Or if you want to get them on retainer before there's a mess, I recommend that as well. But we definitely have some great people, really smart, experts in the MBG sphere. So please use those resources. You can always reach out to me with a question too, and I'll help get you to the right person that can help. So,
Right. And having someone that is um, not just a personal pitch, but it's having someone that understands your organization, that beforehand, not you don't know me, but I have this emergency thing. That conversation is going to be a lot longer than that person, say they've, been embedded in your organization, you've talked to them before, they've come in, they've done training for you, they know who the supervisors are, they've walked your site. That's going to be a quicker conversation and a more fruitful conversation than just cold calling someone,
yeah,
assuming that they'll even pick up the phone.
yeah. So
To
sometimes that.
reinforce your message of it not being self-serving, just for the group, this is Sarah Lee, just because Katie is picking up. I'm just kidding. But I just wanted to say, just kind of that from a self-testimony standpoint, that Tanzi, you have been such an invaluable resource for me. I know when I was first starting out in HR and I was confused and I was trying to create procedures, just talking to you and having that knowledge of you understanding the brewing industry and all the different components that go into it. And you were just so helpful and available. So I do just want to let everyone know that Tanzi's not kidding when she says that. She has been incredibly helpful as a resource for all of us who are kind of trying to figure out what HR looks like in the brewing space. So thank you, Tanzi.
Oh, thank you.
Mhm.
Like you to put that on my website, real big.
Testimonial for
You can blurb
you.
it.
Well, I know it is 11:02, so we have officially gone over by 2 minutes. I apologize, but I just want to thank you again, Tansy, for your time and knowledge sharing today. Really grateful, and she's available if you need any support. Certainly reach out to me too, and I'm happy to get you to the right place. So that concludes our February winter webinar series. Thank you to all of our members who tuned in or are watching these recordings afterwards. We're grateful to have you as members and in our association, and we want to get you everything that you need. So please feel free to reach out anytime. But
Thank
thank
you,
you.
Katie, for being an amazing director and
Oh,
managing the series of webinars. You're the best.
yes.
Take
Awesome.
take care, everybody. Grateful. Cheers.
Thanks, guys.
Cheers.